All right. Court of Appeal in for the Sixth District of the State of Florida is now in session. The Honorable Dan Craver, Judge, presiding. All persons having been before the court call here to the testimony will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated. Morning, everybody. Welcome to an oral argument session of the Sixth District Court of Appeals. My name is Dan Traver. I'm going to introduce the rest of the panel, but before I do that, I will let everybody know that we are streaming live on YouTube. We would be very grateful if people would silence their cell phones so as not to create any sort of disturbance during the oral arguments. To introduce the rest of my panel, seated to my left is the Honorable Keith White, and seated to my right is the Honorable Mary Maradella. We have two cases on today's docket. The first is case number 23-184. I'm sure the lawyers will correct me on the pronunciation if I'm wrong. I'm going to say Susan de Saint-Phal versus Francois de Saint-Phal. And we'll get going. Mr. Foster, how much would you like in terms of rebuttal time? Standard.
I'd like to reserve 2 minutes. If I'm able to. May it please the court and counsel. My name is John Foster, here from Orlando. I represent the appellant Susan de Saint-Phal, who, consistent with the briefs in this case, I will refer to throughout these proceedings as the wife. The appellee I'll refer to as the husband. This is a dissolution of marriage case that brings us here today. We're talking about 28-year marriage, which both parties are in the mid to the past 70s. The husband is retired, been retired for several years, has a net worth of over $100 million with an annual income exceeding $5 million, a net income of $318,000 per month. The wife in this case is 75 or mid 70s as well. She continues to work.
We're all familiar with the fact pattern. You've raised, counting sub issues, you've raised 11 issues on appeal.
Yes, sir.
Where would you like to start? What do you think is your strongest issue?
Well, so I'm going to focus on beginning on the reversal of the alimony, the denial of alimony, which I believe needs to happen in this case. I'll turn to that first. And I want to focus first on the finding of the income by the trial court, because the trial court inappropriately averaged income to arrive at an imputed amount of $63,000 a month for the wife. And in this case, based on the unrefuted evidence that's in the case, the imputing of income based on an averaging of her income based on Woodward versus Woodward and other cases that we cited in our brief simply is not consistent with reality in this case. It does not reflect the wife's current reality.
I wondered a little bit
It is
about
meaningless.
Woodard and Barlow is the other one that was cited in terms of, and you're talking about the average, correct, as opposed to just looking at 2020.
Yes, Your Honor.
It would be, help me understand how we would write that opinion. In the context, would the holding have to be that in this particular context, it was an abuse of discretion to not just use 2020, which obviously in a lot of ways, and now we're 3 years in the past on it, you know, is history proving that that year is just a bit of an aberration?
Well, it's not only an
What's the
abuse.
abuse of discretion in that, I guess?
It's not just an abuse of discretion. It's really a error on as a matter of law, because a misapplication of the law with regard to averaging, especially based upon the unrefuted facts in this case. The case in Woodward involved the case where the income of the spouse in that case had declined. In the other case, the issue was the court inappropriately averaged income when it was clear that the bonuses upon which past income had been based had decreased or been eliminated. That's precisely what we have in this case. The unrefuted facts show that the wife in this case earns her income through a company called WebCorp. The WebCorp in 2019 lost a major customer in the way of Cooper Tires. That leased at least 25% of the warehouse space of WebCorp. That's four of the warehouses out of 16. That was a major impact on the revenues of WebCorp. Likewise, two other customers in the 2019-2020 time period went into bankruptcy, and likewise they lost that customer base as well. That impacted the revenues of Webb, which resulted in the elimination of any bonus income to the wife. And the unrefuted testimony from the wife, as well as from Mr. Adam McGill, the expert that testified at the trial of this matter, was that her current income, as of the date this case was tried, was $35,969. It did not include bonuses because bonuses were no longer being paid to her, nor would they be. And so based upon the Woodward case and the other cases we cited in our brief, the imputation of income based upon averaging, which is basically in the form of monopoly money. It's money that will not put the proverbial bread or food on the table. And as the Woodward case indicates, it's meaningless. And so we would ask that this court reverse that determination of income and find that the wife's current income is $35,969 per month, as the unrefuted testimony at the trial indicated. So that brings us to need. What the court determined in terms of her need on a monthly basis was that it was $50,000 a month. Now I want to stop right there for just a minute. The court determined $50,000 a month. The expert, Mr. McGill, testified at the trial of this matter as to her needs, found that the needs in order to maintain the standard of living that had been established during the course of the marriage was $82,229 a month. The differential between that figure of $82,229 and the $50,000 need that the court determined was 5 discrete expense categories that the trial court took out of that analysis. I'm going to get to that in a minute. The significance of that is that if you take the $50,000 need that the court determined and a current income of $35,969 a month, that's an alimony award of $14,031 per month. That as we speak, this court should mandate the trial court enter on behalf of the wife. And what this boils down to relative to alimony is of those 5 categories of expenses that the trial court took out, which of those categories of expenses will this court require the trial court to put back in? And for each expense item that was taken out, that's placed back in, that will raise the amount of alimony from $14,031 per month. So let's focus on those costs. The first cost that the court removed from the need analysis of Mr. McGill was private jet travel. Now, the unrefuted testimony in this case and the unrefuted evidence was that this couple, this party, these spouses maintained 3 significant residences throughout their marriage. One in Polk County, Florida, Mountain Lake, one at Snowmass, Colorado, and a house in a co-op in New York City overlooking Central Park. And they traveled seasonally between those 3 residences. And they did so by private jet travel. The unrefuted testimony showed that that private jet travel cost that couple $10,610 each month. That was the standard of living that this married couple acquired and lived by during the course of their marriage. Also keep in mind that those 3 residences, Mountain Lake, Snowmass, Colorado, and the New York apartment have all been awarded to the wife in this case. So the seasonal traveling between those 3 residents will be done by the wife, perhaps the dogs that were testified to about in the at the trial, and whoever else may accompany her on those seasonal travels. The cost of doing that will be exactly what it was during the course of the marriage. You don't do half a jet. And yet the court, albeit finding that she was entitled to jet travel, arbitrarily removed 50% of that cost from the analysis. That's $5,305 that was removed arbitrarily without a basis for it, no evidentiary support whatsoever for that removal. And so if this court were to mandate to the trial court that 50% should be added back in and added to the $14,031 per month, that would bring the alimony component up to $19,336, almost $20,000 a month. The next cost category or item that was removed by the court related to the landscaping and treatment of the gardens at Mountain Lake. Again, the unrefuted testimony was that that piece of property is a pretty fabulous home, right, in Polk County. It's 3.5 acres. It's got significant landscaping, beautiful gardens, and it takes $4,190 per month to maintain. The trial court removed that as an expense item without an evidentiary basis for doing so. So that would be another cost item that would be added in to that $14,031 per month alimony that you get to when you look at the $50,000 need and the $35,969 current income of the wife. When you do that, that brings the alimony amount up to about $24,000, almost $25,000 a month. The next category of expenses that the trial court removed was $16,047. And that was an amount that was arrived at by Mr. McGill, the expert in the case, who testified that the methodology he used to arrive at that figure was an appropriate methodology under the circumstances. He testified that the amounts that he arrived at were accurate within a reasonable degree of certainty, and that it was an appropriate amount to require as far as the needs of the wife in this case. The way he arrived at that was, and keep in mind that because of the limitation to discovery that the court imposed on this case, limiting a case like this to mandatory disclosures, what that resulted in was no records from the husband's part relative to expenses that encroached upon the duration of the intact marriage at all. All the records produced by the husband, as limited by the court's rulings on discovery, was after the date of the separation in this case. So we received no expense records from the husband for any portion of that intact marriage, which Mr. McGill said you would always do. And he took his analysis about a year and a half out.
Understand, what was the obstacle though that you faced? And maybe I'm just missing something basic. And if I am, I apologize. But what was the obstacle that you or your client faced in figuring out what those costs were? I mean, we're talking about her need. Obviously, the figure on her financial affidavit is way lower than $82,000 that was quantified by Mr. McGill at the trial. What, in other words, would be to stop her from picking up the phone and calling the country club in Colorado and saying, hey, how much are my dues?
Well, and that's how Mr. McGill looked at it. And in this particular issue, what Mr. McGill did, the expenses that we're talking about make up the $16,047 figure are expenses that the wife had to estimate because they were expenses that was contributed to by both she and the husband. And so in estimating those expenses,
why was an estimate necessary, I guess is my question.
well, because she didn't have the actual data from the husband.
Yeah, counsel, I think we understand this, and I'm sharing Judge Shaver's question as well. But is there a category that we're missing because she wasn't able to obtain that discovery? And in back to Judge Shaver's question, why could not her own efforts obtain the information?
Well, on these figures, keep in mind, she did estimate those amounts.
Correct.
The way Mr. McGill arrived at the differential was he took the records that she had that went into the intact marriage, found that those were less, obviously, than what she had estimated for those, and assumed that the differential would be what the contributions were from the husband. And so that $16,047 amount that we were talking about for those particular expense items is a calculation of what the husband contributed based upon that analysis.
But her attestation under oath was 19.5, right? That was the initial financial affidavit.
Correct. But there were expenses that weren't that, for instance, the New York co-op wasn't in her affidavit.
Understand completely.
And so she had
that
50.
might be, especially with the lifestyle that these parties were accustomed to living, that there might have been some give in those numbers. But I guess what I'm winding myself up to is that if you're talking about a 60,000 plus delta in the course of a month between what the expert says and what the wife's financial affidavit was, I wonder what weight we're going to give the trial court's decision in parsing that out. In other words, you answered my first question by saying that the averaging of bonuses wasn't a discretionary endeavor, it was an error as a matter of law. Is that your same answer as it relates to this?
Yes, and plus keep in mind on her affidavit, her expenses were about $54,000. Okay, so there's about less than a $30,000 difference between what she reflected on her affidavit and what Mr. McGill came to after the adjustments that he had to make. And so there's not an issue with regard to her affidavit. It was accurate. It remained accurate. And the differential and the analysis that Mr. McGill had to do in terms of these particular expenses had to do with those issues or those properties that the husband contributed to, but for which we had no records to determine the amount. So he used methodology that he found was appropriate in the circumstances. And of course, the court in this case denied that $16,047 figure on the basis that as the way the court put it, it was confusing and duplicative. There was nothing confusing and duplicative about that methodology. It's not duplicative, it's not confusing, and it was brought about in terms of the use of that methodology by the court's limitation of discovery to just mandatory disclosures. So if that expense item is $16,047 is added back in and mandated the court to add it back in, we'd be talking about the $14,031 for the alimony that's just based upon the need determined by the court of $50,000 and the current income of the wife of $35,969. Add to that the $5,305 at 50% of the jet travel, then you're up to that almost $20,000 figure. Adding in the $4,190 a month for the share of the landscaping and gardening at the Mountain Lake home, you're up to about the $24,000 figure, and with the $16,000 figure, you're about $40,000 a month in alimony. And then likewise with the other expenses that the court removed. And I would leave that topic for a moment and go into what other evidence showed that this was a case where it was reversible error not to award alimony, and that's the invasion of alimony, invasion of assets. And again, this is irrefutable. The evidence in this case showed that the wife did not have the income to meet her living needs and to pay her attorney's fees, and that therefore, to the tune of $1,292,460, the wife had to invade her assets in order to pay living expenses and in order to pay attorney's fees. I recited to the cases of like Kelly v. Kelly and Margulies v. Margulies, the 4th DCA and 5th DCA cases, where talking about, in fact, Margulies, the trial court there awarded only 1/2 of attorney's fees to the wife in that case, and the appellate court reversed and found that was not appropriate. She should be awarded all the attorney's fees because she had to invade her capital assets in order to pay those and to maintain her standard of living. The court noted, on the other hand, the husband could pay for all the fees and costs out of current income without invading any assets, which is precisely the situation with this case. The husband in this case has a net income of at least $318,000 a month, a stated surplus of at least $250,000 per month. The alimony amounts that we were talking about here, the $14,031, the $19,336, the $24,000 report, all those sums are sums that are nominal in comparison to his income and can be easily paid by him out of income. Likewise with the attorney's fees. So what we'd ask this court to do is reverse the trial court's denial of alimony, mandate that the court award alimony to the wife in the amount of at least $14,031, and whatever other amounts would be appropriate based upon what this court mandates the trial court to add back into that calculation. And then reverse on the issue of attorney's fees and remand it back to the trial court for a determination as to amount. I've got about 28 seconds. I want to go ahead and go to the next topic, I think, real quick. And that is, and one thing I guess I'd be remiss in mentioning this or not mentioning this. The case law is pretty clear that when you have a situation like this, you have the wife in this case is 75 years old. Yes, she's still working, but she's approaching retirement. The husband has significant assets, but more importantly, significant income. At the very least, there should be an award of nominal alimony. And when you think about it, when you look at the calculation based upon the actual current income of the wife and the need is determined by the court of $50,000, A nominal amount of alimony is $14,031.
Counsel,
They're
if-
all normal.
I'm sorry to interrupt. If need is not established, if there is no establishment of need, do you still get nominal alimony? Is there any case that supports an award of alimony without need being established?
Yeah, the cases don't really look at it from that standpoint. They look at it from the standpoint of the fact that in a case like this, the wife is at retirement age. And therefore, things may substantially change in the future. We can't predict that, but the best way to leave that door open, so to speak, is to award nominal alimony.
Why don't you leave yourself a minute?
Yes, I'll leave it. Thank you, Your Honors.
There's a cross appeal in this case. Ms. Henny, do you want to save any time for rebuttal?
No, Your Honor.
All right, you may proceed.
My name is Jean Henney and I represent the husband Francois de Saint-Paul in this appeal. The wife has raised 9 issues, multiple sub-issues on appeal, none of which merit reversal. All of the issues on appeal break down into 2 fundamental questions. Did the trial court err in finding that the wife failed to demonstrate her need for support? And 2, did the trial court err in ruling that the provisions of the parties' prenuptial agreement must be enforced? Both of those fundamental rulings were carefully reasoned, supported by competent substantial evidence, and based on both Florida and New York law. The trial court reasonably determined that the wife did not meet her burden to prove support. The wife left the marriage with a net worth in excess of $35 million. She had a net income of $63,000. And she had reasonable expenses of $50,000. She had a net monthly surplus of $13,000. It is certainly not arbitrary, fanciful, capricious, or unreasonable to deny alimony to a spouse that has a net surplus of $13,000. There was really no dispute about the wife's net worth. There was no dispute regarding the wife's income for the 4 years that the trial court averaged her income. Those figures were taken from the wife's own forensic accountant. The only question is, was it arbitrary, fanciful, or unreasonable to average her net income? It was certainly within the trial court's discretion. Trial court ignored the aberrant year of 2020, except that was used within the average of the 4 years of the net income. The husband's accountant, his forensic accountant said, quote, "When income fluctuates, as a general rule, average is a good thing to look at because you just don't know what you're doing." And then he added, quote, "You average when typically the issue involves varying business income and bonuses," close quote. There was no dispute that the wife had varying business income and bonuses. So it couldn't be unreasonable for the trial court to use the wife's expert's own analysis.
As I understand it, though, the issue wasn't so much the variance. Obviously, the missing bonus is what quantifies it. But what I understood the problem to be is the loss of the major customer, and basically effectively, I can't remember if it was 3 or 4 out of 16 unusable warehouses. So to me, there might be an argument there that this was a pre-2020, pre-COVID existing condition that didn't have any signs like perhaps COVID of coming out of it.
Well, so based on the evidence that was presented, perhaps reasonable people could disagree. But the trial court found that it was more reasonable to average based on her historic fluctuating income. And then also the fact that the evidence was brought out regarding the nature of the business. It was a warehousing business. They owned property, they sold property.
Yeah, so to basically, if you were to answer the first question that I asked to Mr. Foster, it would be an abuse of discretion sort of lens that we'd be looking through as opposed to clear legal error.
Oh, it's absolutely abuse of discretion.
And you didn't read Barlow and Woodard as basically codifying a rule of law that said that it is an error of law to not average in that particular situation.
No, because we have Waldeer and Shira that says it is within the trial court's discretion, and actually Shira says that it's a matter of law, that if you just take an aberrant year that is not representative of previous earning history, that's an error. So, you know, she had this widely varying income. She had the bonuses for these 4 years. The trial court exercised its discretion, and the reversal that this court would write would be extremely impossible to write, that the trial court abuses discretion in failing to take 2020, a pandemic year. And the trial court not only discredited the 2020 year because it was a pandemic year and an anomaly, he discredited it because her tax returns had not been presented yet. So it was all within his discretion. It was well reasoned. He thought about it very carefully and came up with the averaging number well within his discretion based on common sense.
Counsel, what would you say to Mr. Foster's point that we have a wife that she's probably reaching the end of her income earning years? Should that be considered?
Well, yeah, that was brought out at trial. I mean, yeah, it should be considered. It was considered. The trial court considered it in denying alimony. There was no testimony, and she owns the part owner of the web corporation. It's not like she's just simply salaried person. She didn't say she was retiring at any point, you know, I mean, presumption may be retiring, but there is absolutely no legal authority to award nominal alimony when the wife fails to initially establish a need for support. That's if the wife has the need for support and the husband doesn't have the ability to pay, then you get nominal alimony. But the alimony is awarded based on the evidence that was presented at the trial, based on all of these factors which the trial court considered. And he came up with the, you know, a reasonable average amount of income, and the expenses of $50,000 was a reasoned decision as well. It was not arbitrary, capricious, or fanciful in any means.
Counsel, how would you respond to the appellant's contention that his client's ability to prove her need was impaired significantly by the restrictions on discovery?
We would argue that that was certainly not the case at all. The husband provided the mandatory financial discovery and volumes of it. That goes to the $16,000 figure. So what is the $16,000 figure? It's food, meals, vacations, repairs, entertainment, and club membership. Well, at the final hearing, the wife testified to exactly what the club membership fees were. The wife should know how much she spent on food, meals, vacations, repairs, because the husband provided his records for the last 3 years. They're the same properties, so the repairs on the properties would be the repairs on the properties. And entertainment, she should know how much her entertainment is. It's a mystery as to why this $16,000 figure was just this big lump sum. And when you look at the food meal, that's already included in the financial affidavit that was never updated. So the trial court was well within its discretion to say that the wife has the burden to prove her need for support. We don't have a financial affidavit that breaks down exactly what you're talking about with food. If you have this on your financial affidavit, you have this mystery amount of food. The financial affidavit is what one a second DCA case calls ground zero. You know, like this is the main document that you need to prove your need for support that both the court and opposing counsel can work from. And opposing counsel in the court can't work from a lump sum $16,000 figure. If that answered the question. So when you look at the figures that were taken out, so the trial court said, okay, look, I'm just gonna start with the $82,000 figure, and I'm gonna move out certain things. Over 7,500 a month for gifts and donations to the, gifts to the children and donations. Even the wife's expert said, oh, we normally wouldn't include those, but in this case, they were historical and nominal. Well, there's no case that says if the gifts to the children and the donations are historical and nominal, they are properly included in an alimony consideration of need for support. There's the 4,000 in monthly Mountain Lake lawn care expenses. She had the $13,000 monthly surplus.
Well, that's the way that's probably your only way to get around that one, right? Because, I mean, lawn care is an itemized listing on the standard financial affidavit. We see lawn care
Right.
endorsed to us all the time. We don't see $4,000 a month of lawn care terribly often,
Mhm.
but it's an itemized listing. Theoretically, it reflects the party's standard of living at the time. So perhaps it's in its own fault. I think your response to that has to be that there's still enough give based on. But you're not challenging the nature of the expense, correct?
No, I'm not challenging the nature of the expense. I'm just challenging, I'm just arguing that there was certainly enough give in the $13,000 surplus to cover that $4,000 expense. And that we don't fund every little luxury. So, removing the 4,000, and I understand that maybe, if 1,000 or whatever the reasonable expense. But yes, he did remove the entire lawn care expense of 4,000, which is not reversible error because there's certainly enough cushion in the 13,000.
So your contention is basically it's harmless error.
Yes. Yep. And then the $16,000 expenses, that was certainly duplicative, confusing. And then he took out the 5,000 out of the $10,000 in the jet travel. So she still has $5,000, over $5,000 a month she can spend on private jet travel. The trial court then interestingly checked his figure. So he says, I believe 50,000 is a reasonable expense for her monthly expenses. So he looked at what the husband's reasonable expenses were, and they were $30,000. So he said, well, she's got $20,000 in carrying costs on this, on these properties. So if we took out the $20,000 in the carrying costs on maintaining these properties, then she would have $30,000 in monthly expenses. So again, it's arbitrary, reasonable, capricious. The trial court was well within his discretion to come up with a $50,000 figure for reasonable expenses for what she needed to maintain the same standard of living that was acquired during the marriage. And if we go to our cross appeal, the cross appeal has to do with the failure to impute the income that is going to be realized from the sale of the $12,750,000 New York Avenue, Fifth Avenue property. The Sherlock case, generally, the Florida statute says that you, in determining the needs for support, that you consider all income that can be realized from any asset. So the courts have traditionally put the word liquid in front of the assets because that's the most common situation that the courts are faced with. But the Sherlock case says the statute doesn't put liquid in front of the word asset. It can also apply to real estate assets as well. And that's exactly the situation that you have in this case, because you have a non-homestead property that is already listed for sale. The wife had already refused 2 offers on the property. She testified at trial she intends to sell the property. The husband's accountant detailed, if the property is sold, we take out this much for closing costs, we take this much for federal taxes, state taxes, New York taxes, and came up with a figure for what the wife would realize as additional net income, which was over $20,000. Now, of course, if this court affirms this appeal on anything, this is a conditional cross appeal. But this is the perfect case for the Sherlock position that, you know, she has already determined that a prudent use of her asset is to sell it and to maintain a presence in New York with renting instead of owning this expensive piece of property to maintain. So that is our conditional process. The wife did not really touch much on the upholding of the parties' prenuptial agreement or the interpretation of it. It is the husband's position that the trial court was well within its discretion and well within New York law with his interpretation and the upholding of the New York agreement, unless this court has any questions on that wasn't addressed by the husband. We will move on. If there's no further questions.
Thank you.
Thank you.
Mr. Foster.
Thank you, Your Honor. So first, with regard to the averaging issue, whether it's a matter of law or substantial competent evidence, whatever the standard is, the court was wrong. Of course, that's a misapplication of the law regarding averaging, some unrefuted facts in this case. Mr. McGill testified, yeah, you look at it. But he also testified that after looking at it, this would not be in a case for averaging. It's not appropriate. And here's why. The years that were used to average it. Now, keep in mind that averaging included the current income of $35,969. And then the years preceding that included non-recurring, I'm repeating that word, non-recurring capital gains. And it included bonuses that the unrefuted testimony showed and evidence showed no longer being paid to the wife in this case because of the loss of business. This is precisely a Woodward case and Barlow case, and that should be reversed. In terms of lawn care, the court took it out. I'm sorry.
Why don't you just wrap up? If you've
Okay.
got one quick last point to make, but. please.
With regard to the cross appeal, this case falls squarely within the four corners of the cases that say that you don't look at future events. You can't do that when you're determining alimony. You can't get your crystal ball and try to determine what's going to happen in the future. This is totally different than Sherlock, where the court found that spouse was basically doing strategic maneuvering and not utilizing rental properties and lots that were otherwise utilized. This is a piece of the residence that's been in existence with this couple for they've been in New York since the duration of their marriage. It would be
Thank you for the
totally
presentation.
inappropriate.
Thank you for the presentation. I thought this was well briefed and well argued on both sides. We'll
Thank
take
you.
the case under advisement. And you guys just want to stay on the bench and just let the lawyers switch up. We're going to take a quick recess.